Good. You good, Diane? Okay. Good evening. Welcome to the February 10th, 2020-26 Falls Township Zoning Hearing Board. If you can, please stand for the Pledge of Allegiance. All right, before we get started, just make some introductions. To my right is the Zoning Hearing Board Solicitor Keith Bidleymeyer. Stenographer tonight is Karen Browndorf. On Zoom, we have Zoning Hearing Board member Bill Kiernan and alternate Dan Cryer. From the Township, on Zoom, we have Ed Neubauer. Also from the Township in attendance is Matt Dakita and Diane Baree. Before we get started, if anyone's here for petition number 3, Lakeview Terrace, I am in receipt of a...
Yes.
Give me 1 second. I have an issue. Go back. All right, we're good.
Bob?
Yes.
Chris?
Yes.
He's an alternate.
Don?
No.
Oh, sorry. He's an alternate.
Thank you.
Okay, I'm a yes.
All right.
Mr. Chair, if we can just mark their letter as, their previous letter was marked A1, I'll mark this as A2.
Perfect. All right, so moving to petition number 2, petition number 1, Stephen and Mariam Betesh, 226 Thornridge Drive, Levittown, PA, 19054, tax map parcel 13024-096, zoned NCR, requesting a variance for extending an existing non-conforming side yard beyond 50% of the length of the existing non-conformance from section 20941. How you doing? If you can, just please state your name and be sworn in.
My name's Mariam Betesh.
Tracy Miller.
Mr. Chairman, if we can mark some matters for this. We'll mark the zoning ordinance appeal as ZHB 1, the impervious calculation sheet as 2, ZHB 3 will be the hardship letter submitted by the applicant. 4 will be notice to the applicant providing notice of tonight's meeting, and then also to the adjoining or abutting property owners. 5 will be proof that the property was posted as required. And 6 will be proof of publication in the Bucks County Courier Times showing this matter was published both January 27th and again February 3rd, 2026. And 7 will be renderings of the proposed addition. That is all the board exhibits. I'm satisfied the appropriate notice have been satisfied. This matter can proceed.
Thank you. Karen, do you want to swear me in?
Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Could each one of you state your name and spell it, please?
Mariam, M-A-R-I-A-M. My last name's Betesh, B-E-T-E-S-H.
Tracy, T-R-A-C-Y. Miller, M-I-L-L-E-R.
Okay, thank you.
Thank you. You can begin.
So the Beteshes would like to add on to the rear of their house, and the right side has an existing non-conformance, but they wanted to maintain that hallway down the center to add some bedrooms and a bathroom in the back. So that requires extending that existing non-conformance on the right-hand side.
Okay. Thank you, Tracy. Is that all you guys have? All right, any question from the board?
I do. On this hardship letter, it doesn't meet any criteria of a hardship. And this is all stuff that they would like to do, but doesn't meet the hardship requirement. That's all.
Thank you, Bill. Any other questions from the board?
Can you tell us a little bit more about the existing non-conformity? What are the existing, I'm just looking at I see where the proposed one-story addition and the extra setback in the rear. What's sorry.
So the side, the required setback on the side, I believe, is 10 feet, and the existing is, I don't remember the value off the top of my head, but it was between 8 and 9 feet, I think.
Yep.
So it's just to extend that same side of the house straight back along the right-hand side. We're not asking to exceed it, just to keep the same line.
Got it. So you're not going to make that side yard any smaller than it already is.
Correct.
It's already small. It's already non-conforming, you're just going to extend off of that.
Correct.
Understood, thank you. No other questions for me.
Any other questions from the board?
I have none.
Anything from the township? Any public comment at this time? No public comment. Okay, with that being said, I would need a motion.
I'll go ahead and make that motion. I move that the application of Stephen and Mariam Betesh requesting a variance from Section 209-41 of the Falls Township zoning ordinance be granted to extend an existing non-conforming side yard beyond 50% of the length of the existing non-conformance at the property located at 226 Thornridge Drive, Levittown, PA 19054, as depicted on the plans and in accordance with the testimony presented to the zoning hearing board.
I have a motion by Aaron. Do I have a second?
I'll second.
Second by Chris. Nastasha, can you call the board?
Aaron,
I'm a yes.
Bob,
Yes.
Chris,
Yes.
Phil,
No.
I'm a yes.
Thank you guys so much.
Thank you.
Moving on to petition number 2, Phillip and Kristen Mauro, 1520 South Pennsylvania Avenue, Morrisville, PA 19067, tax map parcel 13048-142 and 13048-177, zoned RD1, an appeal of the township's determination that the current tractor-trailer repair operation constitutes a lawful continuation of a pre-existing non-conforming use from section 20975.
Could you please both raise your hand, right hand, please? Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Could each one of you state your name and spell it, please?
Kristen Mauro, Kristen, Mauro.
Phillip Mauro, Phillip, Mauro.
Thank you.
I'm sure if we can mark the following exhibits. ZHB 1 will be the application for zoning ordinance appeal. 2 will be a packet submitted by the applicant. I'll mark that collectively as 2. And they can explain as they go through. 3 will be notice to the applicant providing notice of tonight's meeting. 4 will be 5 pages containing 5 color photographs. 5 will be proof of publication, the Bucks County Courier Times. 6 will be proof of posting of the property as required. That is all the board exhibits at this time. I'm satisfied the appropriate notice have been satisfied. This matter can proceed.
You may begin.
Okay, great. So we're here today under section 209-75 to appeal a decision made by the township regarding a concern that J&L Truck Repair is operating outside of its approved UNO. The property is a non-conforming status located in Riverfront Section 1 district. It has been since its inception a typical neighborhood auto body repair garage servicing primarily Class 1 and 2 vehicles. We share a driveway with the property and have done so peacefully next to the business for 15 years. However, we're here today because the property was sold and the auto garage business was replaced with a tractor-trailer repair facility. Tractor-trailer repair is specifically listed in the Falls Zone Code as high industrial use. That distinction exists because tractor-trailers have a significant greater impact on surrounding properties. J&L Truck Repair was approved by the township to continue the property's prior non-conforming use. Somewhere in that process, there appears to have been a disconnect. Either the prior use was misunderstood or it was for some reason assumed that passenger vehicle repair and tractor-trailer repair are interchangeable. As a result, was that the neighborhood auto garage became a high industrial operation.
Ms. Morrow, could you just slow down? She has to type down
Oh, I'm
everything
sorry.
that you're
I'm
saying.
sorry. Became a high industrial operation, circumventing the variance process that normally protects the neighboring residents. No hardship exists that prevents the property from continuing operating as a neighborhood non-commercial auto repair shop, and the expansion happened solely for the owner's benefactor. It's at the expense of the health, welfare, and safety of its neighboring residents. So I did put a little highlight reel together of that kind of goes through like the impact of what it's like next to this property. So, let me just pause this real quick. So this is our house, and this is like our bedroom window right here. And these areas right here, these are all the trucks that come in. So in general, there's a lot of times where trucks sit here and they're 20 feet from our bedroom window. And they're all within this, 100-foot range, which, the diesel exhaust is a carcinogen. In that 100-foot range, like that's a danger zone to be exposed to all those carcinogens. So this is just a couple of short videos. They're 15, 20 seconds. It's not very long. This is our backyard. This is standing in our backyard. So they were working 7 days a week, 10 hours a day. I'm going to try to talk to you over this because this is my day today, is I have to go through the day and experience these noises and go through what, it's like. So this video is in my bedroom window. I'm sitting on my bed. This is, they were doing something outside, delivering something, but this is the general noise of the air brakes and the idling that goes on. So even the tools are louder and more intense than they were before. And
Ms. Mauro,
yeah,
just so the record's clear, when you play these, if there is a date and time, could you just identify it? Because we're going to need it for the record.
okay, yeah, I mean, there is, I do have right next to here.
Yeah.
So this is November 19th, 2025 at 5:33 p.m. This one was September 20th at 3:47 p.m. This one is Tuesday, September 23rd at 7:26 p.m. This one is November 5th at 6:15 p.m. So every parking spot is now working bay there, so that wasn't the case. They did operate inside of their building before. And then when the lot is full, they put the cars up on the skirt, and it's very hard to turn it out. This one is 1 a.m. in the morning. A truck, often trucks come in and they park for the next morning, and then they sit there and they idle for half hour, 45 minutes. And there was a week where it was every day during that week that they came in at 1 or 2 o'clock in the morning. This is at 10 o'clock at night. This one's 5 a.m. in the morning, and this was hours on end of idling. This one is in our bedroom again. The noise travels into our bedroom. It vibrates the house. It vibrates your body. Like it's very difficult to experience that. And so the township has worked to try to reduce the overnights, but apparently it's hard for them to stop it because they don't know when the trucks are coming. So, and then they do have people in the back that sleep in the trucks too. And this is the modified entryway. Let me open up. So, I mean, the prior business was a neighborhood auto. They've been there for 50 years. It was calm. The township didn't even know who we are because we never complained. We never had any issues. But with this new business, it's not the same. It's not the same use. It's a completely different business and it's in a non-conforming property, and it shouldn't be able to move up to a high industrial property without going through the whole variance process. So that's why we're here today.
I think at this time, it's best if, before we ask our questions, the township, if they have anything to approach the appellant with.
Sure, just a couple questions. Hi.
Hi.
My name is Greg Heleniak. I'm the township solicitor.
Hi.
So I'm here tonight because of the type of action you filed, an appeal of the zoning hearing board, zoning officer's determination. I have to come and
Right.
defend it.
Right.
So just a couple questions. When did you first learn that the property had been sold?
I'm not really sure. I mean, they started cleaning up and, you know, I think it was about
June 1st.
June, middle of June, July.
And that is of 2025?
Yes.
And when did you first notice that the vehicle repair shop was servicing tractor trailers as part of its work?
So in the beginning, there was a lot of coming and going. There was trucks, there was a bunch of landscaper trucks there for a while. They came and went, and you know, so it was probably, you know, we saw the tractor trailers, but it did take a little bit of time for us to experience what I showed you in the video for us. So, but it was a reasonable amount of time. It was like 2 months in business when we said this is not the same.
So you're saying like August, September at that point?
September.
I'm sorry, go ahead.
September.
Did were the landscaping trucks and other trucks would you have considered them a new addition to the operations?
I mean, we weren't sure what was going on. You know, you saw DP cleaning up and you said, well, something's going on over there, so.
Oh, so were the landscaping trucks being serviced or were they working on the property?
I believe they were working on the property. They were there for a couple weeks and then they disappeared, and then there were some tractor trailers that came in and then tractor trailers left, and then there were construction vehicles. So it was, in the beginning, like it wasn't sure what was going on.
But you would say you noticed a change in the operations on the property in September of 2025?
Yeah.
Okay. And that would be consistent with what you attached to your application as, I guess, E2, which was an email to the code office?
Yes.
And that's dated September 10th, 2025?
Yes.
Okay. And in that email, which the board has, you say, I'm assuming the DP had some level of variance or grandfathered in use status for the property. Is that correct?
Right, yeah, so we were vaguely aware. I mean, this is all new to us, you know. We were there 15 years, never had an issue with any kind of zoning. But we were aware that they were in a kind of a non-conforming status, and not that we understood exactly what that meant. Now I do, but yeah, so we kind of had a sense of like, it was supposed to stay what it was.
And so part of that awareness and that assumption, you were aware that that property's been used for vehicle repair for quite some time?
Yes.
Longer than, you said you were here, you've been here in the township 15 years?
Mm-hmm.
So it was probably at least longer than 15 years?
Mm-hmm.
And I'm just going to ask you to say yes or no just for the...
Yes.
I'm
Yes,
not
sorry.
trying to be like
Yeah,
a
no.
lawyer here. It's just, I know Karen, it makes it
Yes.
easier for her. Where was I? So it had been for, as far as you know, it had been vehicle repair for a long time.
Yes.
Okay. And in the 15 years that you've lived next door, were there ever larger trucks being serviced there prior?
There was not any diesel level trucks, no. I mean, maybe a box truck, but it was all smaller scale vehicles.
Are there trucks that operate on Pennsylvania Avenue regularly? Like, do they go up, do tractor trailers go up and down Pennsylvania Avenue regularly?
Yes. Yeah, there's lots of tractor trailer activity.
And there are other businesses that utilize tractor trailers in close proximity to your property?
Yes. Not 19 feet from my window, but yes.
And I think some of the videos that you showed tractor trailers on the shoulders or sitting in front of your house as well?
Yeah, they were in front of that property. So they use that skirt to stage their vehicles.
And so you after you reached out to the code office on September 10th, 2025, when did you file your appeal to the zoning hearing board?
So it took a while to get an answer. I did keep asking repeatedly, like, they were, I think, trying to mitigate the problems and make everybody happy. But I mean, my concern was that it's not the same scale of business. There's more than just the sound. There's the safety aspect of it with the diesel. So I had probably every conversation I asked them, but what about my concern of this? And I think it wasn't until the date's in there. I wrote an email to Matt asking, please, I need an answer on this.
I'm guessing that's the email you included. It says December 18th.
Yes. So I was given that advice to word it that way by a friend of mine who said, well, if you need to get an answer, say this and it should get you an answer.
And you got an answer on December 18th, right?
Yes, and I did get an immediate answer.
And would it be accurate to say that the answer from the township was that there was no zoning violation?
Right.
But you had been aware since at least, say, September that, in your opinion, something different was happening on the property?
Yes.
That's all I have right now. Thank you.
Okay, you have anything else?
No.
Okay. Any questions from the board at this time?
Yeah, I have some. Most of your complaints are issues with them, like, working off hours and 7 days a week. And bring that up to the zoning office. I think in these emails, it said that they were fined for some violations. Isn't that the best route to go? Let the zoning board, or not the zoning board, but the zoning department, when you do your complaints, if they're valid, with the zoning regulations, that they would find them in court, give them a citation, and that's where it should be taken care of.
Well, that addresses some of the overnight issues, but it doesn't address the overall problem is that, we're existing next to tractor trailers with the noise. Even they're allowed to be there during the day, and so then we have to exist next to that tractor trailer noise all day long in our house. And, the safety problem with it, all the diesel fumes coming off, that doesn't go away just by stopping them from doing overnight stuff.
But on that part of the road, there's several businesses that do with tractor trailers and everything. It just happens, this one has to be close to you, but there's a lot of noise from truck traffic, the other companies along that road, and also the exhaust fumes. I mean, that all contributes to your problem. But I think that the township is responding to complaints that are against the code, and I still feel the court is the township's, writes them a citation and it's handled in court. That's how you get it.
Well, having other tractor trailers around doesn't mean we should be susceptible to even more. I mean, we are 19 feet from where they operate, and it's in a non-conforming. When you buy a house and you know what your situation is, and you expect it to be within that confines, and there is for us, I don't want my children. I have 2 children. I don't want them breathing that air. And there is a difference between being 100 feet from a truck and then being, across the street or far away. I mean, when they're that close, that's a danger zone for those particles.
No, I understand that, and I can appreciate you looking after your family, but the site, I don't know how long the house has been built there, but you're saying they were in business as a repair shop for 50 years. So the only difference is they went to a little bit larger, to larger vehicles.
But it's a whole different zone. It's now a high industrial facility. And a year from now, if they want to say, well, we already have tractor trailers, let's have an overnight trucking depot here. Well,
that would have to go for a,
well, then why doesn't this? If that would have to go for a variant, then why wouldn't this have had to go for a variant?
well, this was deemed that it was a continual operation by the township.
And that's what I'm contesting, is that it's not.
All right, that's all I have right now.
Hey, Ed, Newbauer, could you touch on where you're at in the process with notice of violation or citations? Just bring us up to speed so the zoning hearing board knows what's going on with enforcement processes.
Around second week of November, I sent them a notice of violation letter to Mike DiNardo, the property owner, and I sent it to J&L Trucking.
Yeah.
So after sending them a letter, it still kept happening, and I filed citations, and we were supposed to have court on February 3rd at 9:30. The owner of J&L Trucking continued it, so now I have them in court April 7th at 9:30, both of them.
Okay.
That's where we're at right now.
And what are the extent of the violations? What do you have them for, Ed?
Just a noise ordinance,
Okay.
and after 10 till 7.
Does it cover any of the noxious odor or fumes or anything like that?
No.
Okay.
Is there anything about working on vehicles outdoors in that RD1 district?
Is there any restrictions on the automotive
Restrictions
repair?
on automotive repair outdoors?
In RD1, yes,
And that's what this is, right? This is RD1.
correct. This is a non-conforming use. So it falls back to the original zoning designation when the original use occurred, which would have been a heavy industrial district.
So it sounds like this is kind of the crux of it. The previous repair shop was non-conforming because it was an auto repair shop, and that is not an RD1. But the previous repair shop was someone correct me if I'm wrong, was working during quote-unquote normal business hours, was working on vehicles inside the shop. There was limited impact on you, although the use was non-conforming. The new shop, also non-conforming, also not allowed under RD1, but now has a significantly different pattern of use, including outdoor, as you've shown us, outdoor work, overnight and weekend work, And in fact, you know, working not just in service bays, but in the parking lot and even the driveway and even, and also, you know, I would also ask what the code says about, you know, people sleeping in their cars overnight, or in their cars, or they're in trailers, or in their whatever. Like, is that also a, you know, where does that fall in terms of the districting? So again, there's a bunch of different issues here that I just think are, yeah, they're continue to be non-conforming, but in a completely different way.
But just for the board's benefit, there's a distinction between whether the use is permitted as a legally existing non-conforming use and the enforcement issues that the township is dealing with in enforcing the code. So the underlying use being permitted is what, as a continuation of the illegally existing non-conforming use, is what the Mauros are appealing. The ancillary issues of the hours of operation, the noise,
The activities
are,
of the use.
I think what Aaron's,
are enforcement issues.
what Aaron's trying to ask, is there any restrictions within the use permitted, the non-conformity? Is there, vehicles can't be stored outside more than 30 days? Is there anything saying that all work must be done within a fully enclosed building? Is there anything like that in the ordinance?
No, there's not.
Okay.
And if I could just add, though, to the extent that, I mean, in seeing some of these, and I know these were concerns that the Mauros had brought up in their initial complaints with hours of operation, their letter of intent did indicate that they were only going to be operating from 8 in the morning till 5 in the evening. So if they're not doing that, then they're out of scope for their application, their letter of intent, which would be a violation. Again, the use itself would be permitted, but they put restrictions on it themselves. Then there's also the noise ordinance. You can only have noise, you know, within certain hours that they would be violating.
So I think with the evidence we have today, is there anything else the township can do zoning-wise as a violation for the work being done outside, or is it all falling under a noise violation at this time?
At this point, it is under the noise violation, hours of operation based on their letter of intent. And if there are people sleeping in those cabs overnight, that is a violation.
Do you have any proof of that other than the trucks idling? Do you see people going out to start the trucks? Is there anyone coming in and out of them trucks? Do you have video of that?
I have a video of them with hitting the brake lights on the truck being back there. I mean,
there's oftentimes, they have a fenced-in area behind the facility that trucks are locked in there overnight. There's numerous videos that we have of those vehicles idling or having their compressors running overnight. There's a couple where they hit the brake light, so you can visibly see that they're all the way at the end of the property in a truck, sitting in it, you know, overnight. But we do have multiple videos of them in there overnight, getting out of their trucks, peeing on the side of the road and getting back in their trucks. We've called the cops numerous times on that, and nothing ever happens with it.
Okay. And you understand why the township at this time only has a noise violation on the property?
I don't understand, no, because, I mean, tractor-trailer repair operates under, it's a specific use in high industrial zoning. So, and auto repairs under light industrial, they're two separately defined things. I don't understand how they're interchangeable. That is the basis of why I'm here today, because to me, if it's defined separately, it's a different use. And if it's a non-conforming, you can't change the use, you can't expand, you can't change to another use. And this, I feel, is a change to another use, because it's a separately defined use.
And Matt, your determination was based off solely an automotive repair, correct? The continuing non-conformance of an automotive repair business.
Correct.
Okay. Does the automotive repair in the Falls Township Code distinct between cars or trucks?
No, there is no distinction between the different types of motor vehicles.
But there is a distinction in high industrial that says tractor trailers, oh no, that's not the right one. Right here. Sale, leasing, repair, and outdoor storage of material handling equipment, tractor trailers, motorhomes, campers, equipment, and machinery. That's under high industrial. It's a specific use.
And the township is prepared to present why the interpretation was made the way it was.
Can you move forward with that, guy?
Absolutely. I just didn't want to jump in unless the board was done with the applicant's presentation.
Understood. Unless, before you get started,
I do
Greg, any other questions from the
Yeah,
board?
other questions?
I do have one more question. So I think we have two things going on here. We have them violating our ordinance, and the other thing is they fall under heavy industrial because that's been in operation for what, 50 years, and so they do still fit in that under.
Bill, it's actually the opposite. They're falling under, what,
River District.
RD1, they're not high industrial, that's the point, Bill.
But non-conforming.
But non-conforming
We-
light industrial.
We will walk you through that. Yes.
Okay,
All right.
okay.
Give me
We'll
a
need some guidance there,
Any other
because again,
questions
my naive question is, it's RD1, it's not high industrial, it is non-conforming. We're stuck with this kind of loophole of a previously non-conforming and now a newly non-conforming, but in a different way.
And I mean, the law, is generally that you can't expand on a non-conforming. You're not supposed, you're supposed to be more restrictive than expansive, and expanding, this property will now be a high industrial property. So it can expand laterally to whatever high industrial next business that it wants to do. Well, if it can't do that without a variance, then why could it do it now without a variance?
I'm getting
Go
it, I
ahead.
can.
Go ahead.
But-
Actually, I have one more question. So we talked about, whether they're sleeping or not in their cabs, and I can certainly understand long haul truckers issue with their trailer, need to bring it in. They find a spot, they're hoping to get in. They got to wait an hour or two to get a spot in the bay or to have a mechanic come and look at it, whatever it is, and so they're sitting in their truck waiting. Versus, I just need a place to stop for the night, and here's a place I can stop, and I'll pull in, and there's a spot, and just sit there overnight and then pull out in the morning. Do you have any evidence that that might be happening? Do you have any, again,
I believe-
not that you're the investigative detective
I believe
responsible for this, but
most of the ones that come in at 1 o'clock in
getting
the morning
serviced.
are getting there to get service the next morning. There are ones in the back of that's locked up, that those are the ones that I think are staying there for whatever reason.
Yeah. Okay, thanks.
Last question from Matt. In your expertise as zoning officer, from date of approval to the nonconformity to today, did that business intensify and expand the nonconformity, in your opinion?
No, it did not.
Okay. Any other questions from the board? Great.
So as a preliminary thing, and I'm not going to go through a whole question and answer with Matt on this because I don't want to spend any more time on it, because the board can take notice of what's included in the application packet, including the letters of intent that were sent in by the applicant regarding their use in April and May, and the issuance of the certificate of occupancy in June of 2025, and the timing of this filing of the application, which is dated January 18th, 2026. Even if the most generous date that we have here of the applicant learning from Mr. Takita's response about no zoning issue being December 18th, that email, the appeal is dated 31 days after that response, and that was a Saturday, January 18th, 2026, which means the township did not receive this appeal until after the appeal period had already ran. So I'm going to move.
That's not true, because it's on a Saturday, and then there was a holiday on a Monday, and you guys were closed.
So yes, so it needs to be filed within 30 days of the determination that was made. So if December 18th is the date of that determination, if that's what the board wants to recognize, the appeal was not received within those 30 days. It was received.
But if it's on a weekend.
Ma'am, I need to finish.
Okay.
And no, it's not on the weekend. It's not a mail rule when it comes to the zoning. It's not a filing rule. It does not make it to the next business day. The appeal needs to be filed within the 30-day period. That's the law when it comes to zoning appeals.
So,
But
I'm sorry, Greg, if I can just interrupt. So I see an email here from Kristen Mauro on September 10th. It doesn't look like the township responds back to her until December 18th.
And I understand that. There was no written item until that December 18th email from Matt that said no zoning issue at that point. I could make an argument to the board that it's a new or should it known. Once you find out about the use that you believe is improper, you have 30 days to raise that appeal. So I could make an argument to the board that September 10th is the date that the 30-day appeal period starts. But even if we use the December 18th date, that appeal was not received by the township until after the 30 days had already ran, which is after January 18th. But I'm happy to address the substantive things because the applicant's here for their hearing tonight, and I think it's only fair to give the board the entire story because you have these questions as well. But I need to raise it as part of the record and present that to you. You know, if you so choose, I think the board does lack jurisdiction because of the timing issue. We'll start with this. I think we've established, Matt, have we established that the use of this property has been a vehicle repair shop and auto body?
Yes.
Please, sorry, I thought he already was.
Matthew Takita. I do.
And I think the board can take notice that Matt is the zoning officer and is qualified to answer questions in this arena, unless there's an objection from the board on that. Matt, we established that the use of this property as a vehicle repair shop and auto body?
Yes.
And to your knowledge, when did the property start being used for that use?
Somewhere around 1974, 1975.
And that's based on paperwork that's in the township file?
Yes.
I'm we're going to move on from that. At that time, 1974, 1975, were permits issued for this property?
Yes.
I apologize, my things are a little out of order here. Matt, do you recognize this document?
Yes.
I can hand these to the board and the applicant.
You said Township 1, Greg?
Thank you.
That's fine.
So Matt, what is this document?
It's an application for a building permit.
And when was this submitted to the township? It's on page 3.
1970, March of 75.
I think if you look at the top.
Oh, I'm
right.
sorry. Yeah, no, November 20th of 74.
And if we go back to the first page, what is listed as the use of the property?
General automotive repair.
And was this use at that time also reviewed by any other agencies?
The Bucks County Planning Commission had reviewed it as well, I believe.
I get to do a little dancing. Is this a letter that you referenced there?
Yes.
Thank you.
And Matt, what's the date of this Bucks County Planning Commission letter?
December 11th, 1974.
And I believe if I take you to the second paragraph, what is the use listed as here?
Automobile repairs.
I'll leave one more from the 70s here. Thank you. Okay, Matt, what's this document?
This is a building permit,
And what's it dated?
March 10, 1975.
And under remarks, what is it listed as there?
Auto repair garage.
And then above that, what is the zoning district listed as? I think it's on the wrong line, but.
It's zoned HI, heavy industrial.
Okay. So after the letter of intent for this property came in, did you review the file for the property?
Yes.
And did you review the township zoning ordinances, both past and present?
Yes.
I do not have a copy of this. We have one copy of this, but Matt, what is this document?
It's the zoning ordinance from 1955.
And this is also current through January 16th, 1960, is that correct? Okay.
Yes.
And you said this property was, is it your understanding that this is the ordinance that was in effect at the time that the documents we just discussed were approved?
Yes.
And you reviewed this?
Yes.
I think you just said this was permitted under HI, heavy industrial?
Correct.
And so if I read to you that Section 801 of this ordinance says use regulations, a building may be erected or used, and a lot may be used or occupied for any lawful purpose except the purposes specified below, or any purpose substantially similar to any so specified, provided that no use which is noxious or hazard shall be permitted except in accordance with Section 909. Does that sound correct?
Yes.
And if I represented to you that the
Excuse me, is there some definition of noxious and hazardous in there?
Not to our knowledge. Not to our knowledge. So the accepted uses listed here are a dwelling, an abattoir or a stockyard.
Those would not be permitted.
These are not permitted.
Correct.
The accepted uses,
Yes.
right? These are the ones that cannot be permitted in the HI. That correct?
Correct.
Okay. Distillation of bones and woods, incineration of garbage, junk yards and salvage yards, and manufacture of certain products, including an arsenal, fertilizer, potash, gypsum, rubber, wood pulp and fiber, and trailer parks. Is that accurate?
Yes.
In your interpretation, is a automobile repair shop or vehicle repair shop similar to any of those uses that are accepted out?
No.
Did the zoning change for this property over time?
Yes, it did.
And it changed right after this property was initially approved, correct?
Yes, shortly thereafter.
In 1975?
Yes.
And in 1975, was this, would the use have been permitted under the 1975 ordinance?
Yes, it was.
Did the property, it was still HI at that point, correct?
Well, somewhere between 75 and 79, it became HIA.
HIA. And it, at that time, and how long was the property zoned HIA?
It was, Up until, I believe, the 90s, it was, well, no, it was owned even longer than that. At least until the 90s, it was owned HIA.
So if I were to represent to you that the property was zoned HIA until the institution of the Riverfront District in 2006, would that be accurate?
Yes, that is accurate.
So I'm going to hand you an expert of the code from
Sorry, Greg, one
November.
You guys can take a seat if you want, if you don't feel like standing.
November
Up to you, yeah.
2004. That look like that?
T4, unless you're going to mark the 1955 ordinance that you don't have a copy of. Did you?
Yes, sir. So this is T5.
Okay.
So Matt, you said this is a copy of the 2004, or excerpt of the 2004 ordinance?
Yes,
This is HIA district, correct?
correct.
I guess we'll go to the third page. This lists the principal permitted uses shall be as followed, starting on the second page.
Yes.
We'll note as the definition Ms. Mauro testified to, the sale, leasing, repair, and outdoor storage of material handling equipment, tractor trailers, motor homes, campers, equipment, and machinery was permitted in the HIA under this ordinance, correct?
That's correct.
And then there is also a number 9 there. Can you read that for the board?
Any use of the same general character as any of the above permitted uses, including accessory uses, which are customarily incidental to said uses.
And this property received a subsequent certificate of occupancy, correct?
Yes.
When did it receive that certificate of occupancy?
Around 2005.
And that goes hand in hand with the business license?
Yes.
Is this a copy of that application?
Yes.
And Matt, what does it list as the use at that?
Auto body and mechanical repairs.
And this application was reviewed in 2005, so the 2004 ordinance would have been effective at that time?
Yes.
And just to be clear, you were not the zoning officer in 2005?
Correct. I was not.
Based on your review, what use would this have qualified as at the time in 2005?
It would have been technically both the repair of tractor trailers and any other use of the same general character.
So if we're looking at the any use of the same general character use, you're saying that same general character for an auto body and mechanical repairs would be back to that repair of tractor trailers, et cetera?
Yes.
Those two uses are linked together.
Correct.
Would it also be determined that this was a could be determined at that point that this was still a continuation of a legally existing non-conforming use?
Yes.
And the property was rezoned to, I think as you testified, to the Riverfront District in 2006?
Yes.
What would have been the effect of that rezoning on the use?
It would have no impact on that use.
And that use would have been entitled to continue?
Yes, as a legal non-conforming use.
And when does that legally existing non-conforming use end?
And it doesn't end until the use is either abandoned or there's a change in the use.
Based on your review of the 1955/1960 ordinance, the 1975 ordinance, the 2004 ordinance, in any of those ordinances, was there a distinction made in the type of vehicles that fell under the vehicle repair use?
No, there was no distinction made. There was no separate definition for either one of those types of vehicles.
And is that still true under the current ordinance?
Yes.
Is this a copy excerpt of the definition section of the current ordinance?
Yes.
And we'll mark this as T7.
Matt, can you read the definition of motor vehicle repair garage?
Motor vehicle repair garage, an establishment where motor vehicle parts and accessories are sold, and facilities where parts may be installed. An automobile repair garage, including paint, spraying, and body work and fender work. This use includes an auto body shop.
So I think, as you said, is there any distinction in the type of vehicles that are serviced at a motor vehicle repair garage?
No.
Is it your understanding that prior to the letter of intent you received in April and May 2025, that was the use that was operating on that property?
Yes.
And based on the letter of intent that you approved in, I guess, June of 2025, is that the use that was approved to operate there as a continuation?
Yes.
And just briefly, and I think the board has taken a bit of notice of this, but could you describe the character of the other surrounding properties in the area?
The surrounding area is generally industrial. There's a large warehouse behind subject property. There are other auto repair facilities to the north and directly across the street. And there are some contractor shops and along that stretch as well.
And I think the applicant themselves testified this, but there's common tractor trailer traffic in the area, correct?
That's correct.
Right. He's all yours.
This time, the board have any questions for Greg or Matt?
Yes, I have a number of questions. So it's very clear that auto repair, vehicle repair, car repair, truck repair, even diesel truck repair is at least clear to me that is allowable under the code. I totally understand that. I can't remember which is this, T2, T3, the zoning ordinance, heavy industrial A. 2004. T5, okay. Thank you. Let me read back to you in section A. Where architectural design, landscaping, compatibility with natural, skimming. The standards are intended to require maximum attention to the proper site design, including the location of structures and parking areas, proper ingress and egress, development of interior street system where applicable, architectural design, landscaping, and compatibility, and maybe proposal with natural foliage, soils, contours, drainage patterns, and the need to avoid visual intrusions and performance nuisances upon adjacent residences and residential zones. Okay, so it seems to say right there in heavy industrial A, which this was, that whatever is being done there should do whatever they can do to avoid visual intrusions and performance nuisances upon adjacent residences and residential zones. It also says about, sorry, let me stop there. Any rebuttal or question, like, do I have that wrong? Am I reading that wrong?
It does say that, certainly does make those statements. I think there are a couple things to say about that. One is that this use had been in existence for 30 years prior to this ordinance being drafted and enacted. So that language had already, the use had already existed as a legally existing non-conforming use for quite some time by the time this language came into effect. This is, as we know, a zoning ordinance is forward-looking to uses that are then developed under that ordinance. So this intent is well and good, but the use was already in existence. And furthermore, a purpose paragraph does not have any enforcement capabilities by the township. Although there are other tools that the township can use for enforcement, this language in Section A under purpose is not enforceable in any way.
Okay, fair enough. I don't have the 1955 language, so I can't read what it may or may not have said at that time, but I'll take it under your, I'll take that it probably may have some similar purposeful.
There's actually no purpose section
No purpose in
the
that
HI.
section. But it did make the comment about, excluding anything noxious or hazardous, ill-defined as that may be. So there was at least some nod towards there's got to be some limit to what the uses are. The second thing I want to point out in that same T5 zoning for heavy industrial A is that it does mention the outdoor storage of tractor trailers and motorhomes and whatnot, but nowhere does it say anything about the outdoor work on that, right? Now, it also nowhere says that all work should be performed indoors either, granted, but is there anything that, and I know that as other applicants have come to us over the years, we ask them tough questions about, well, okay, you're going to have an appliance repair shop. Are you going to do all the work inside? Are you going to keep all the stuff inside? What's going to be stored outside? What's going to be stored inside? Because neighbors and property owners in the area care about whether work is being done outside. Sounds like in this case, there's a lot of work being done outside. So again, I guess I'll pause and make that a question to your reading and understanding of the law here, the indoor-outdoor, is this a relevant aspect?
First defer to Matt to answer the question as to whether there is a portion of the code that regulates the outdoor work being performed.
There isn't any section of the code that addresses outdoor work for this use. And oftentimes with repair garages, there will be work that's done outside, even no matter what size vehicle. But again, if it's violating a noise ordinance, then that's a violation that we can enforce. Or if they're working outside of the hours that they indicated they would operate.
Okay. Nothing else from me, thanks.
Any other questions from the board? No questions. Greg, is that all you have?
That's all I have.
Okay.
And I would ask the board to uphold Matt's determination as to this.
Is there any questions you guys have for Greg or Matt?
Yeah, I do. Because there is a piece that I'm a little bit confused about because in 2005, when they filed and got their UNO for the auto repair, what was auto repair in the code at that point? Was it under light industrial or was it under heavy industrial?
Auto repair was still permitted, sorry. Auto repair was still permitted under the HIA district.
Well, it's permitted under there, but is it permitted under light industrial as well? No, auto garage is not heavy industrial.
I'm basing this on this specific property. And the zoning of the property was HIA.
But when you're dealing with non-conforming, this is my confusion here, because when you're dealing with non-conforming, you can't make something more non-conforming. So if you go back in a zone and you have a different zoning, then you can't go back to high industrial if you went to light industrial for the auto zone. So in 2005, when it was issued, because otherwise, if you're saying that that property is high industrial, then why would it wouldn't be a non-conforming?
I think there's a bit of confusion as to what a zoning district classification is. So, something being heavy industrial or light industrial is the area on the map where certain uses are permitted, or the regulations that apply to those areas on the map.
Right.
So when a use is non-conforming, just because the use appears somewhere in the code under light industrial does not make it a light industrial use. It is just a use that is permitted in light industrial. So it doesn't mean that it is also not permitted somewhere else. You will find in the code that a commercial property can be permitted under the commercial district, but can also be permitted in the riverfront district, or multifamily is permitted in R4 and also in the riverfront district. So that's not how that works. This is the fact that it's a non-conforming use, and the township's position is that vehicle repair was the use that was established back in 1974 under the code at the time, and that's the use that has been continued for 30 years, and that use, when it was established and how the property has been used under that use, did not make a distinction on the type of vehicles that are repaired as part of that use.
I understand that, but it did make a distinction on tractor trailers specifically, right? And what you're saying is they were both in high industrial, so they're both similar in use, and they both are aligned in that respect. But my argument is that there are two different uses in two different classifications currently in today's zoning. Auto repair exists in light industrial, tractor trailer repair exists in heavy industrial. And so your argument is that, well, back in the 60s, they were both high industrial, so therefore they are both the same and exist and can exist in that property.
Right. I think our argument is up until 2006, so 20 years ago, both of those uses were entirely permitted from 1974 all the way through 2006 by right in some way, shape, or form in the HI or HIA district, which this property was.
But it is not currently.
It's correct, but because
Currently,
the use was,
it's a light industrial for auto repair, and it's heavy industrial.
it's not light industrial, and it will never be light industrial, and never was light industrial.
Well, that's
what I'm
where
trying
it
to say.
exists in the code.
The use is vehicle repair. Where it's permitted under the code in whatever zoning district it's permitted in now is irrelevant to the analysis. It's the use was established as vehicle repair in 1974, and it continues to this day as vehicle repair.
Okay, but they also said that there's tractor trailer repair in 1974. Is that correct? That was a line?
In the 1975 code, yes.
It had a distinction specifically for tractor trailer repair. Is that correct?
But that's not to the exclusion of other vehicle repair.
But what you're saying is they're defined separately, and you're telling me that they're the same, and that's where I'm saying, why would you define them separately if they're the same use? There would be no reason. You would just say it all under one umbrella.
So the thing is, the terms were not defined. That's the thing. The terms were not defined. So when we analyze it for the continuation of a non-conforming use, we look to see, how it was interpreted back then. And when the ordinance doesn't give you specific definitions, you look to see what items were approved. Now, from the very beginning in HI, this was a permitted use. And then it changed to HIA. Again, it was permitted. They didn't define or differentiate between, you know, any kind of motor vehicle, whether it be a truck, passenger vehicle, or anything like that. So
But
the term truck, automobile, motor vehicle, they were all interchangeable at that point.
But tractor trailer was defined separately.
Not until after this use
Not-
was already
not until-
established.
And to that end, it was a term used in a use regulation, but again, it was not a defined term. They didn't say tractor trailer and made it different from any other motor vehicle. And then in that same list of permitted uses, it also said any use of the same general character, which opens up, it's very broad language. And in order for us to permit the continuation of a non-conforming use, standard of our analysis is based on similarity. It has to be similar, not identical. It has to be similar. So that broadens the.
But it also, there is language about to the welfare, it can encroach upon the welfare of neighboring residents, the health, safety, welfare of neighboring residents. That is a specific piece of the non-conforming where it's saying that, yes, you can change your use, yes, it can be similar, but when you're talking about expansion, it can't encroach upon the health, welfare, and safety of the neighboring properties. So I think it failed that test. Definitely fails that test because it definitely affects the health, welfare, and safety of the neighboring property.
And the township's position is that there has been no expansion. It's the same use that's been in effect since 1974, when it was established.
Mr. and Mrs. Mariam.
It modified the building. They modified the building to fit the trucks in, first of all, because they didn't fit into the building. So to say it's the same use, I don't know how you can say that. If you have to modify your building to fit the trucks into it, that's not the same use.
You can modify a home to fit more people in it. It's still the same use. I'm not sure, and I hope that we did not confuse the narrative here in showing our intention of showing the 1975 ordinance and the 2004 ordinance was to illustrate that the character of this property throughout most of the existence of this use was contemplated by the zoning ordinance until the enactment of the Riverfront District, but it's still the township position that when this use was approved in 1974 and early 75, before the 1975 ordinance even went into effect, vehicle repair was the use, and it has remained vehicle repair for the past 31 years, 32 years.
Mrs. Mauro and Mr. Mauro, can I ask you a quick question? If this were, if the situation were different, if it was still tractor trailer repair, but happening inside this new bigger building, only during the operating hours that were expressed during the application, and did not have trucks idling outside your door, would you still have this complaint? Because it seems like we keep revolving around, is tractor trailer repair, allowed or not? And all the evidence we're hearing is that yes, it's allowed. And I have been saying for a while now, I think it's the manner in which it is being performed at this particular site that is the issue, less about the fact that there's tractor trailer repair going on.
I don't believe that they can operate in a manner that is compatible because they stage the cars all along the side of our building. I mean, they going into their bay and out of their bay, they're pulling in. They're back in, coming out the back and through.
They have to get in and they have to get out, granted, right? But that sounds like a smaller impact than what you've been describing and what you showed us in the videos.
Do you think, to your knowledge, that this property is being used for anything other than automotive repair?
Yes.
And what is that?
I believe they're shipping out of there. There's cars, 16 car carriers with cars on it. If you're repairing your car, why do you have cars on the car carrier? You wouldn't. And then there's tractors that come out of the back of the yard and leave out, and then they come back. They don't go into the bay, they come out from the back, they leave out, and then they come back.
Are the car carriers shipping cars that are being repaired?
No, no cars are repairs. It's only tractor trailers.
Okay.
And oftentimes, the repairs on the trucks, they have to have them running to get them up to operating temperature, which involves the vehicle running for over the 5-minute idling law that Pennsylvania has. And we've have it documented from even August and September that these trucks will run in a certain spot for hours on end.
But
If they moved everything to inside using one door that they have, which they had to modify to get the trucks in, like, you're not going to have every vehicle you're in there working on sitting and idling inside of a building. It'll be outside, causing a disruption to our house. Our house vibrates, the noise comes through. You feel it in the bed at night when they have them running.
And we hear you, believe me.
Yeah.
But at that
I don't
point,
see how they would be able to function with the trucks inside the property.
at that point, it becomes an enforcement issue and not a use issue. Do you
But,
understand that?
but thing is, how can that be the same use and not an expansion of use? Like, so you're saying I could buy any car dealership, any auto repair I want, and just toss a tractor trailer repair facility in there, because that's the same.
It's not defined.
Under Falls Township ordinance, yes.
I can? Oh,
It
well, I
doesn't-
guess I
It
got
doesn't distinct between automobile and tractor trailer.
It does, though.
Not the nonconformity.
It has a specific use for tractor trailer repair.
If I may, what the distinction is, if this was a new application and that business did not exist there prior to, for instance, if they came to the township and said, hey, we want to put a tractor trailer repair facility at that location, and one did not exist there prior, like some kind of repair shop did not exist there prior to, let's say they wanted to put it in like a warehouse that's been historically used for just shipping, they then would have to come in front of this board for a use variance because it's not otherwise permitted. And that's the problem that you're running into, which is historically that building has always been used as a repair facility. They want to continue on, and the township has said that that is a continuation of a non-conforming use.
But even in the same, non-conforming says even in the same scope, you can't expand your business. It can't be more. It can't be, they're not operating in the building. They're operating all over. Their footprint is more. There's more vehicles in the back. They're doing more. So there is an expansion there. Even if it's in the same scope, there has been an expansion of use. And it says that even if it's in the same scope, you can't expand more than a certain percent.
Well, I have a question on that. Expansion and growth are two different things. So expansion is they're going to expand the buildings, expand that, but what you're saying is that they got bigger and more volume of traffic in there compared to what they were before. That's not expansion, that's growth.
It's not the same company.
It's not the same company, though. One company ended another company. That's not natural expansion. That's a whole different
it's-
company.
Same use. It's just that this use is bigger and more volume, and that's where it's not expansion, it's just more volume, more business.
But that is part of the definition of expansion is the expansion on use, even within the same scope. Even if it's aligned in the same type of business, in the same scope, if it's expanded upon, it has to pass the test of not being encroaching on the neighboring property's health, wellness, and safety.
And that's what we're saying would result in enforcement issues by the township. And that's what they're taking the noise violation to court. Is there other codes that they can enforce? I don't know that answer. But at this time, is there any other questions from the board? I'm going to open it up for public comment. If there's anyone from public comment, you can come up, sir.
Good evening.
How you doing, sir? If you can, just please state your name and spell it for Karen.
Mike Donardo, Mikedinardo. I'm the property, I'm sorry.
Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. So I am the property owner for 1520 South Pennsylvania Avenue. I just came out to hear my neighbors' concerns and see if there's anything I could do to mitigate their concerns and make their life a little easier. And that's what I'm here for.
You just give us one moment.
Hey, Mike, how you doing?
Good, how are you?
Just hearing some of the concerns from the next door resident, is there anything your tenant would take upon themselves to fix or correct any of the issues that is being addressed today?
I believe they are. They're trying to keep trucks that do run further in the back or on the other side of the building away from my neighbor. They're trying to keep trucks from pulling in at night and running overnight or pulling in at night. We did have a survey done, and we're going to try, we can't extend a fence or put a gate out closer to the road, but we can put some bollards up and chain it off when they leave. So that is the key there. When the tenants leave at the end of the day, they're going to make sure there's no more access to the parking lot so trucks do not pull in. And I believe, you know, my neighbor did say it is getting better. I did hear that. So they are trying. And I'm here to help.
What is the reasoning for the trucks idling all night?
I don't know. I know some of these trucks have some sort of automatic battery charging system. So when it's cold, and it's been really cold lately, these new trucks have these devices where they automatically turn on and run to try to charge the batteries so they don't fail when they need to start the following morning. They did have some trucks closer to my neighbors, but they've moved them to the back lot and away again on the north side of the property. They did park a trailer between the properties, kind of block or clean up the view so they don't have to look, meaning the neighbors don't have to look at the repair shop. So they did park a big trailer there. But if they don't like that, I'm sure we can move it, you know. The neighbor had every good intention, I'm sorry, my tenant had good intention on closing that off so they didn't see the repair building. Is that an issue?
It is an issue. It's a big wall down our driveway. It's not a matter of seeing.
Yeah, if you guys are going to cross conversation, you got to speak into the microphone.
It's not a matter of being able to see the trucks. We hear the trucks, we feel the trucks. That's the issue. I don't care that you have a trailer there. And you've known at this point, at least for the last 10 days, that there was a hearing coming up. This afternoon, a truck right on the property line where your guy spray painted the pink lines yesterday sat there idled for 90 minutes. That doesn't show me that you guys have any care of fixing any of these concerns.
Wait, say that again, please.
You had a truck idling
Okay.
on the property line 16 feet from my window, dining room window, for 90 minutes today. That doesn't seem like they're making any effort to change anything.
Yeah, I don't operate the business. I'm
I
just
understand
the
you don't
property-
operate the business, but your tenant does.
Yeah.
And this is what they're doing to us on a daily basis.
Mike, is the tenant here?
They are.
Okay.
They don't have any representation, so I don't want to speak for them, but if they want to, you have a question for them, I'm sure they could.
Are they comfortable coming up?
Olga, are you comfortable coming up?
How are you?
How you doing? So you hear the concerns from, oh yeah, I'm sorry, can you state your name and spell for Karen so you can be sworn in?
Sure. It's Olga, Lizoun. Olga is spelled O-L-G-A. Last name is L as in Larry, I-Z-O-U-N. I do.
Can you address some of the comments from these next door neighbors on how you're fixing these issues that are happening?
We are, as Mike said earlier, that we're trying. So the main concern was when Ed showed us that there are some trucks that were having, like running at night. And I explained to Ed that some of the trucks have APU units, which do help to keep the batteries alive at nighttime, which we can't really control. That's the way the truck is built. But we spoke to Mike as well, so we're trying to move them further from the house so they will not hear or have any impact on when they sleep at night. During the day, some of the trucks are running because some of them have to run because we need to make sure the work is done and everything is working properly. So if that's not permitted, then we're gonna try to do something else and move them maybe further in the back. I honestly don't know. But we're trying to close off the property as well. So trucks, when we leave, don't come on the property because we cannot control that. So the property right now, our driveway is not blocked, meaning we don't have any gates. So people come at night, although we have all kinds of signs everywhere that there's no parking and the trucks will be towed, but some of them, unfortunately, they still don't read or listen, that's something that we cannot control, unfortunately. That's why we're trying to block the driveway so they will not stay overnight and, sleep or wait for us until the morning. But it's still in the process, though.
Question for Ed Newbauer. Is there any idling ordinances that the township can enforce?
Not that I know of. Not sure if the police would have something, but
Private property might be different. Okay. Any noxious odor ordinances that you guys have that you can enforce?
There are general provisions for noxious odors.
Okay. All right, any other questions for the tenant or landlord from the board? Okay. Thank you, guys.
You're welcome.
At this time, the board's going to step into an executive session.
Mr. Chairman, if we could just let the record reflect that the board took an executive session. During the course of that executive session, the board needed clarification on the 1955 ordinance as discussed by the township, the 1974-75 ordinance, the changes that were instituted to the ordinance, and also the current zoning. And that was discussed during the executive session.
So moved. Any more public comment at this time? Okay. So with that, yeah, any more board comments? And Township, you guys are, okay. So I would need a motion on this agenda item.
I'll make the motion to deny the application.
Motion by Bill, do I have a second?
I'll second it.
Second by Chris. Nastasha, can you call the board?
Bill,
Yes.
Aaron,
Yes.
Bob,
Yes.
Chris,
Yes.
I'm a no.
Thank you.
Sure, yeah, I just want to say that I think on behalf of all of us, we hear the concern, and our hands are tied a little bit in terms of what the zoning board has the authority to do and not to do. As you heard our attorney say, this is what we discussed in some depth just now. We would love for you to find the help and the relief that you need, and many of us wish that we could have done that for you tonight. Had we done something different, it's not clear that that would have helped you. So I just want to say that.
Thank you. All right, with that being said, I would need a motion to adjourn.
So moved.
Second.
Aye.